Do you know that the Justice Sanjeev Khanna is going to be the 51st Chief Justice of India? In this context, let us dive into the details of CJI like appointment, qualifications, removal and his powers. Qualifications. The CJI should be a citizen of India. He or she should have been for at least 5 years a judge of a high court or of 2 or more such courts in succession, or have been for at least 10 years an advocate of a high court or of 2 or more such courts in succession, or be in the opinion of the President a distinguished jurist. Appointment of the CJI. The CJI and the judges of the Supreme Court, SC, are appointed by the President under Clause 2 of Article 124 of the Constitution. As far as the CJI is concerned, the outgoing CJI recommends his successor. The Union Law Minister forwards the recommendation to the Prime Minister who, in turn, advises the President. In the second judge's case, 1993, ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the CJI. The SC Collegium is headed by CJI and comprises 4 other senior-most judges of the court. The Collegium system is the system of appointment and transfer of judges that has evolved through judgments of the SC judges' cases, and not by an act of Parliament or by a provision of the Constitution. Administrative powers of CJI. Considered as master of rosters, it is common to refer to the office as primus inter pares, first amongst equals. Besides his adjudicatory role, the CJI also plays the role of the administrative head of the court. In his administrative capacity, the Chief Justice exercises the prerogative of allocating cases to particular benches, decides the number of judges that will hear a case. Thus, he can influence the result by simply choosing judges that he thinks may favor a particular outcome. Such administrative powers can be exercised without collegial consensus and without any stated reasons. Removal. By an order of the President only after an address by Parliament has been presented to President. This should be supported by a special majority of each House of Parliament. Special majority is a majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present and voting. Grounds of removal. Proved misbehavior or incapacity. Article 124. 4.